What's up, everybody? I wanted to give you all some updates as to the ongoings of the Ashes of Creation and Intrepid Studios lawsuits. As many of you have probably noticed, things are really slowing down. I've commented on this before. We're really hitting a stretch where there's just not a lot to talk about as we're going through hearing after hearing. However, there was some big news today. And that big news was addressed by Stephen Sharif himself in the official Discord, and it was that the Nevada lawsuit has been dismissed. As a reminder, this was the very first lawsuit. It was TFE Games versus Stephen Sharif and John Moore. This is the one that had the allegations of misuse of money, handing out money to family and friends, and these claims of basically stealing from the company is what they were essentially claiming was happening. This one had been put on hold while we were going through the California case. And as you might remember when we last spoke about it, they basically hit a pause button and wanted to figure out what to do next. And apparently this was the next step, was just to dismiss it. This was a joint agreement, so both sides agreed. It was filed without prejudice, which means that it could be refiled again in the future. I really doubt that that would happen, but whoever knows what might come from these things. And of course, Stephen Sharif is pointing this out as a win for him, and it might be. I really don't know. I have no internal knowledge as to why TFE Games maybe decided to dismiss this. However, I do think that potentially part of the reason for why this has been dismissed is that TFE Games no longer owns any part of Intrepid Studios or Ashes of Creation's assets. As you might remember, that was all transferred back to Intrepid Studios, which really disrupted the California case, and this kind of led to where we're at there. However, because of that, I imagine it'd be very hard for TFE Games to show that they've suffered any sort of damages because they no longer have any of those assets. It's no longer anything to do with TFE Games. It's all back with Intrepid Studios. So who knows exactly why the reasons are. I do suspect that might be a big part of it. They really can't get much out of it because they can't show damages. Maybe it'd be different if it had been filed, including Dawson and others as plaintiffs, but it wasn't. It was filed as TFE Games versus Stephen Sharif. So that one seems to be gone, and very interesting indeed. However, there are still ongoing legal issues with other lawsuits. One of those is the one brought by Jason Karamanis against Stephen Sharif. In this one, we've been waiting on a response, and actually it was Karamanis, I think in a YouTube comment, actually let us know what was happening, which was that Stephen Sharif's lawyer asked for an extension to respond. And as of right now, the expected response will be May 15th, I believe, to that initial filing. And per Jason's comments, he also, I guess, expects for there to be a countersuit, possibly with defamation. I wonder why that might be. Who knows? Has he been on several shows discussing the case and everything that's been going on? I don't know. Maybe you all know better than I. But he apparently expects some sort of defamation suit as well. There is also still the ongoing issue of the employee class action lawsuit. That has had zero response at this point. That one's just sort of still sitting there. Who knows what will happen from that? As a quick reminder, there actually were two initially. One has been dismissed. That was quite some time ago. But we do have one that's still pending, waiting for something to happen. And then that lastly brings us to the California federal lawsuit, which has been the one with the most ongoings, the most stuff happening as we went through temporary restraining orders and preliminary injunction hearings and attempts to remove lawyers and all of this sort of dramatics that eventually might make its way to a Netflix movie of some sort, or maybe a Lifetime show. So where we are with that is this motion for a receiver. Stephen and his law team, as we last talked about, has filed for this idea of a receiver, essentially almost like a court-appointed CEO, someone that can inspect everything, look at the books, and look at everything that's happened and approve sales and stuff like that. And that, of course, was not something that TFE Games wanted. And so that's been kind of the ongoing conversation piece in the court system. The last thing we got from that, there was an attempt to have what's called an ex parte motion put forth, which would have sped up the process. It would have moved it essentially from, I think, May 19th to a much earlier, probably would have already happened. However, the judge denied that motion, did not feel that there was any need for an ex parte. essentially, Stephen was unable to demonstrate that there was this urgent need to have a hearing right now. From that, it sounds as though so far there's been no attempt at a second foreclosure or sale. And so the judge basically said, there's really no urgency here. We'll still have the motion, and I'm not ruling on the motion, but we're going to have it on May 19th. With that, the judge also very clearly asked the two sides to confer and to potentially try to settle on a receiver of limited powers, potentially having something to do with an Article 9 sale. That apparently did happen. There was a deadline for that, which I believe was April 27th or somewhere in there. And there was no deal. They could not come to an agreement. Of course, you had Stephen's side wanting basically everything. They wanted a receiver that would not only manage the assets and control a sale or foreclosure, but also look at the books and really determine whether or not Dawson's debt was even still good after he went through the first foreclosure. As you might remember, that's an interesting argument they have, that the first foreclosure has now gotten rid of his lien. There's a lot to it that they were wanting a receiver to look at. And of course, TFE Games said, no, we don't want that. TFE Games did say they would be okay with essentially what we had before, a custodian-like approach of someone who just sort of held the assets and maybe facilitated some of the sale, but they did not want someone with powers to really look through the financials or anything like that. Also did not want to pay for it, was another part. So essentially we were left with nothing happening of substance. And the hearing for that will be May 19th, I believe, for the receiver. So we'll know more here in 2 to 3 weeks as to what the outcome of that might be. With that, we'll also have a amended complaint that will likely be put forth. The first couple of requests from the original complaint, the prayers were essentially against TFE Games and owning Intrepid Studios property. And now that they don't own that, it was essentially either throw it out and start over or amend the complaint. So they have agreed to allow for an amended complaint to be put forth. The due date for that is May 15th. And then TFE Games will have 14 days after that in order to respond. So there might still be some shuffling of dates. I know I've thrown a lot out there for you, but there's a lot that will happen here mid-May, potentially, as to the outcomes of the case. The last thing I want to kind of talk about really quickly, and this is not to agree with one person or another. I've always tried to take a very middle of the road approach here and just trying to figure out what actually happened. Like, well, let's get to the facts of what's going on. I do find it kind of interesting. Some of the questions as to why TFE Games is not allowing a receiver. Keep in mind, as we talked about at the very start of this, the Nevada case, they claimed that Stephen Sharif and John Moore essentially stole a lot of money. That was their claim. They misappropriated millions of dollars, and they were wanting a judgment for that. And what would a receiver be able to find? Well, if you had a full-on receiver, they would look through all these finances. And I would think that would help your case, right? You would have a receiver that would report to a judge. It would be very official if they would find anything like what was alleged. But we still have this very big resistance to a receiver, which it just throws in a lot of interesting thoughts to my brain. Who knows actually as to why that is? But I don't know why you wouldn't want that. I'm someone who has very common thoughts. I like to think by the common denominator. I think red herrings are red herrings. It's rare that you find things truly exotic and reason or nature. And so always look for the common denominator. And I don't know why they wouldn't want someone to help them find things against Stephen and do it in a way that actually has legal implications because it's done through a federal court. That doesn't seem to add up in my head for whatever reason. In addition to that, they have yet to start another Article 9 sale. When we first started this, they seemed very gung-ho on like, hey, we're going to start this process again. Yet they haven't, which raises just a lot of interesting questions as to why that is. Now, if you remember, the judge was very, very clear in that if you do this again, if you do another Article 9, let me know. So they do have to tell the judge if they're going to try to sell it again. I don't know if that's part of the barrier, but I don't know. There are just some interesting questions in my mind as to why the behavior is the way it is. Again, I like to also look at behaviors. Why are people doing the things they do? And what's the most likely reason for that or the rationale. And this one's a hard one. I don't understand. It seems to me that a receiver, if everything was above board, would help facilitate the sale really pretty quickly, because a judge would sign off on it the whole way, and you would have limited pit stops in the road, right? You would have limited prevention of you completing the sale if it was done in this fashion. So I don't know what the rationale is. I do think it's an interesting conversation point. Perhaps we will learn more as we get to see their response. That is not me saying things are all rosy and we're going to get Ashes of Creation. I've pretty much said from day one, we will not get Ashes of Creation. No matter who owns the IP, I really do not think we will. But it's just interesting food for thought. So I appreciate y'all watching. And as always, I will put the documents in the description. So do not trust me, bro. Go read for yourself. And yeah, we'll be playing some games this weekend. So if you aren't following or subscribed, make sure you are. You catch those notifications. And as always, I'll keep posting about the Intrepid Studios lawsuit as we learn more, which should be in a couple of weeks. So I'll see you next time.